All right, I think it's a few minutes after 11. Do you want
Yep.
to get started?
Let's go ahead and get started. So good morning, everyone, and welcome to our webinar, Science Sealed and Delivered. My name is Sully Encalada, and I'm the Director of Business Development with DSS Condo. We are a complete project management company. We have been in business since 2014. Presenting this webinar today, we have our COO, Michael Poe, and joining us from Haber Law, we have Daniel Jovanov, our Senior Associate, and Alexander Leon of Counsel and Board Certified in Construction. So now I will turn it over to our panelists that will tell you a little bit more about themselves and about our presentation. Guys?
Good morning, everyone.
The next slide there. Sorry.
Yeah, we can go to the next slide.
Oh, yeah. All right.
Michael, go ahead.
I'm sorry about that. Good morning, everyone, and a happy Tuesday. As Lee mentioned, my name is Michael Poe. I'm the CEO of DSS Condo. I've been with DSS now almost 5 years. My background is I'm a certified general contractor as well as a roofing contractor, and I've been in the construction industry about 20 plus years now, dealing with concrete restoration and the condominiums for about 10 plus of those years.
Danny?
All right, so good morning, everyone. My name is Danny Jovanov. I'm an attorney here at Haber Law. I have a bachelor's degree in civil engineering, worked in construction for a short time before going to law school, and then went to law school and have been practicing in construction law for about 10 years now.
Good morning, everyone. My name is Alex Leong. As Sully mentioned, I'm a board certified construction attorney. I've been practicing construction law exclusively for the last 7 to 8 years and practicing law for 10 years. Looking forward to talking to you about the construction contracts, because that's my specialty. So we can go ahead and get started by going to the next slide. Great. Sully?
Yeah, so today, this is what we have in today's agenda. So first, we're going to talk about who we are, Haber Law and DSS Condo, who we are and what we do. And then we're going to talk about the major components of the contract, terms and conditions, exhibits. Then we're going to go over examples of what to avoid in the contracts, and then bid sheets, tear down, and finally we're going to go over some Q&As. Right,
Great.
And then with that, we're going to get started.
So this slide is really just kind of outlining the different kinds of contracts that an association may be involved with, but our conversation today is focused on the third one, capital improvement contracts, and what exactly are the pitfalls and important provisions that property managers and associations alike have to be aware of in order to understand how to use the contracts to their benefit, right? The goal is to try to have contracts in place that are vetted by your attorneys and your owner's representative, and be able to use them as both a sword and when necessary to leverage against your contractors, but also as a shield in case there's a claim or dispute that comes up that arises. So if we can go to the next slide. And what the major components of a contract, generally speaking, are terms and conditions that are outlined and negotiated in the contract itself. But equally important are the exhibits that are attached to the contract, because those documents are going to be what is going to define the project and define the limits of the liabilities here. And I think we're going to get started, and Michael's going to be the first one to discuss a little bit about the major provisions that we would talk about. Let's get started with that. Michael, if you can go to the next slide. Talk to me about these two provisions and why they're important from your perspective as an owner's representative.
Absolutely. So the first one we have here is the description of work. And as you can see here, it's the contractor's bid. So obviously going into a contract and getting ready to execute a contract, you want to make sure that all your T's are crossed and all your I's are dotted. Basically meaning that contractor's bid has been vetted by your owner's rep, which is the second one here, bid reviewed by owner's rep. Meaning, what does that mean when it's vetted? We're going to go in there, we're making sure that items are what they need to be, repair types are in place and they're accurate, that you have the latest version of that contractor bid, meaning the one that's been gone through clarification already with the contractor, as we've gone back and forth with negotiated certain items, and we're making sure that we have all the specifications and repair types and repair details built into that bid itself. Meaning you don't want something that's kind of somewhat vague, call it, when it comes to having a contractor's bid and it calls out for a small example would be a repair of full depth repair to a slab. Okay, but that detail now for that repair, we want to make sure that that detail is inclusive of shoring, for example. And at times we'll find that it's not. And these are those little pitfalls that we find and things that are missing that later on become change orders or missed scope throughout the process, or scope creep, as we'll discuss later on as we go through this. So you want to ensure that the contractor's bid is accurate and has been reviewed, call it by your owner's rep, to ensure that all those items have been dealt one by one, have been reviewed, have been scrutinized, and ensure that it's all part of it. The next item we have here is time for completion. In regards to time for completion, incorporate project schedule. Absolutely. Now, when it comes to a project schedule, this is what we use to somewhat, one of those items that we're going to use to hold the contractor's feet to the fire, call it, throughout the process, throughout the construction. So we want to ensure that it's been negotiated ahead of time prior to engagement of a contract and execution of an agreement, meaning that schedule has been vetted by your owner's rep. It's even gone through your legal status, your legal team as well, and it's gone through the owners. You've reviewed it, you've come to it, you understand it's broken down task oriented section by section. You know, a good example is ensuring you as a building, you understand your building better than others. So when we come to it, you want to make sure if your building's in seasons, if it's out of season, when is it? Are it the best for them to start by the pool? Is it best for them to start on the front side of the building or the west or either side? You want to make sure all that's determined ahead of time. And that's when it goes down, and also understanding your set start and finish date as it goes through it.
Danny,
If you want to chime in on the.
Yeah, I was gonna let Danny kind of come in and explain his experience on litigating these kinds of schedule issues on some of the other projects. If you go ahead and give us an example of that, Danny.
Right. And with respect to the liquidated damages point that's in there, that's one of those ways where you can use the contract as a bit of a sword against your contractor, where you kind of agree prior to the start of work how much in terms of damages or a daily rate of damages that the contractor is going to pay to the extent that he doesn't finish the work on time. So you can use that and leverage it to say, I'm going to deduct this amount, or you're going to pay a penalty essentially of this amount if the work is not done, so that you can enforce the contract and essentially tell the residents of the association, give them a better idea or have an expectation that the work's going to be done on time and as expected.
And to dovetail on that point, liquidated damages, for those on the call that are not aware of what those are, basically it is an agreement by the parties, the association or the contractor, to just set a daily burn rate essentially of what the damages are going to be if the contractor doesn't complete the project by a date certain. And that daily burn rate can fluctuate. It's a business item normally when you negotiate on behalf of the association, but you need to take into account, is the association pulling a loan for this project, and what's the interest rate on that loan, and what's the daily cost of delays, right? And the association has to, generally speaking, have a predictability of what the damages are going to be, so that they can then enforce those damages on to pass those down to the real party at issue, which is the contractor for delaying its work. But liquidated damages are a complex legal mechanism that should be vetted by your attorneys, should be reviewed and analyzed by the board, as well as the property manager and the owner's representative, so that you're leveraging and making sure that your damages are covered, but at the same time, it cannot be punitive. So it can't incentivize progress. It has to be a relatively speaking accurate prediction of what the damages would be if there were a delay. And the reason that that's important now at the front end of the contract is so that everybody's on the same page as to exactly what the costs are going to be of those delays. If you leave liquidated damages outside of a contract, the association still has the right to go after a contractor or a vendor or anybody else that they engage for damages, but now you're having to engage experts to determine what are the actual damages involved here. What does it actually cost for a project to be 10 days delayed or 15 days delayed? What effect does that have on the association? And that can be resolved on the front end to save you a headache on the back end. So if we can go to the next slide, we can talk about some other important terms and conditions. Contractual costs are obviously a very important provision and every board and every association understands the cost of the contract is probably the first thing they're going to talk about, because that's what you're reviewing in the bid. That's what you're looking to spend in order to actually do the project. But how you actually frame the contract cost in the contract depends on the contract you have, right? There's lump sum contract, there's cost plus contract, and a unit price or time and material contract. And I'm going to give a brief description of what each of those are, and then I'll let Michael kind of give some examples of certain contracts are more beneficial than others. A lump sum contract is basically exactly what it says. It's a number that is given to you by the contractor. You don't know what profit margins they have in that contract. You don't know what they're paying their subs, but you know that that number ideally is not going to be exceeded because they're telling you on the front end, this is how much it's going to cost, and that's it. By comparison, a cost plus contract is essentially you are reviewing the documentation that is provided by the contractor of what their actual costs are, and then what's added on to that is a contractor's fee for overhead and profit. So it will be X number of dollars of work performed in the last month plus our fee of 5 or 10 or 15% or whatever you negotiate. That's what a cost plus agreement is. And a unit price contract is effectively where you negotiate exactly what the cost will be for a particular scope, be it on a per square footage basis or per lineal foot or whatever it is, and you attach a price to that so that you understand that as the contractor is doing its work and as they're submitting pay applications on a monthly basis, you're aware of, well, they've done 100 square feet of work in this particular area of the property, and therefore they're entitled to payment of X number of dollars in relation to that unit price. Michael, can you give us some examples of where a lump sum would be beneficial versus a unit price or a cost plus?
Yeah, absolutely. And first of all, you did a great job of breaking that down. Now, with that being said, what I'd actually like to mention is relate to a typical, call it concrete restoration contract or a project that they'd be performing on one of these condominium associations. Now, actually within those contracts, within those bids, you could actually identify these 3 to 4 items within it between certain line items when it comes to it. The contract itself is a lump sum or a unit price, but within it, you have certain circumstances where you're looking at items that are broken down as lump sum, really identifying the unit of measure when it comes to it. So you have lump sum items. An example would be paint of the building. Exterior paint of the building is a lump sum item. And if you had a separate contract for that, that would be a lump sum contract. Now you have items as far as cost plus. Now cost plus examples within your typical day, call it association, condominium, capital improvement projects, when it comes to concrete restoration, would be built within that contract. You have certain items where you would consider allowance items. Allowance items being that you have a general contractor, but there's some electrical or plumbing work that needs to get done, but they're unable, it's a hidden condition, they're unable to determine what it is. So they're going to build an allowance for that or provide you an allowance, which later on, once it's identified and the specification is provided throughout that, and it's been exposed, now that contractor is going to go back and provide backup for the work that's being performed by that subcontractor and put his markup on top, call it his profit on top of that. Now it's a cost plus when it comes to that. Within the time and material, certain circumstances within, again, the same type of project, concrete restoration. A nice example there would be some contracts are broken up when it comes to hurricane, demob and remob, protecting the building, securing the building, call it. A lot of them are broken up by time and material, meaning the contractor is going to be paid for the amount of employees and time spent on there for a rate that's already within the contract and agreed to for each role. They're going to be paid for that time plus material. Now the materials, they need to purchase additional plywood to secure certain areas. Now it's going to be that material plus their profit and the time of all those employees for that time, which needs to be monitored, again, call it by your owner's rep. We would be on site monitoring that activity. And the last is the unit cost, which we've all known, we've discussed. When we go back to and we see how it's broken down, whether it be square foot, linear foot, cubic foot, and those are the types of repairs you have there. So you have X amount of quantities for the type of unit measure at a certain rate, and therefore it gives you a total cost. And it's every time they perform that work, when they're going to be paid for work completed, they're being paid that square footage or that unit footage on that unit price that was agreed to originally.
Right. And you kind of touched on that right at the end there. The next major term and condition is payment terms, right? The association as the owner's rep needs to be aware of exactly what's in the contract as to how the contractor wants to get paid and by when they want to get paid. Some contractors want to get paid twice a month. Some contractors want to get paid once a month. Some contractors want to get paid on milestones. So the time for making those payments needs to be negotiated and discussed as part, and that works within how the association operates, because every owner, not just associations, but developers as well, everybody deals with their finances differently. So we need to be aware and have a conversation on the front end to make sure, okay, well, do these payment terms work for your association or your project or your loan, for example? Making sure that if you have a loan, if you have a bank or a lender that's involved, they're aware of what their obligations are, and you're aware of what your obligations are under the construction loan agreement, so that you can make sure that you pass those down onto the contractor, and no one is ever in breach of those terms. But I think, Mike, you were talking about the documentation that is submitted with regards to the contractual costs. How does that play into the payment and how that works? What would be DSS's role in that circumstance?
In regards to what was the question?
The process of payment on a monthly basis, or however often it happens. You talked about documentation with regards to the contractual costs. So talk to me a little bit about how that documentation plays a role into how the payment is functioning, and what DSS's role is in that payment review.
Okay, so yes, absolutely. That documentation, having that ahead of time, first of all, as Alex mentioned, yes, you do want to take the time, you do ahead of time prior to establish what it truly takes for your association to produce. Your owner's rep and your engineer of record, we're going to have discussions with the engineer and understand what it takes time for us to review the payment applications, scrutinize those payment applications, get through it and provide it to you, call it after with an approval stamp saying, here you are, it's ready for processing. But you as an owner need to understand what that process looks like on your end. Is it a 1 week, 2 week turnaround to have a check issued to the contractor? That time needs to be taken into consideration. So as Alex mentioned, nobody's in breach later on. The last thing you want to do is be in breach, because it typically takes you 3 weeks and we're giving the contractor 10 days instead of those 15 that we actually need. Now, in reviewing those payment applications and having those proper line items identified, whether it be lump sum or cost plus and time and material or unit price, that goes hand in hand with reviewing that payment application and referring back to what we originally had and understanding that breakdown and understanding the work that was completed on site. So we know if it's a lump sum, we're basing it on some sort of percentage. If it's a cost plus, we need to understand and request that backup, make sure we have it for what was paid, and refer back to their contract for whatever that increase or that percentage of overhead was included in there. And for time and material, if it's being billed at a time and material rate, then we're going to go back and review that contract and ensure they're billing at the rate agreed to, and verifying the hours that are on site. It all goes hand in hand with reviewing those payment applications and ensuring you're not overpaying or paying for items that you shouldn't be.
I think that actually ties into our next slide. And Danny, if you want to jump in and talk about how payment documentation sometimes it results in litigation or change orders, please chime in.
Yeah, I mean, oftentimes, for example, with lien releases and other supporting documentation, as your owner's rep is reviewing them, I've seen countless cases where people will get into disputes over not providing the supporting documentation. So they won't provide warranty documents, or towards the end of the project, they won't provide the shop drawings or other documentation that's required for payment. And inevitably at the end of a project or during the project, it'll hold up payment and people will get into a dispute that could result in liens or bond claims and expensive litigation over not complying with these specific requirements. I mean, the payment terms are a very, very key and important provision in a contract that comes up in a lot of litigation.
Great. So we moved this on to the slide because Michael was talking about kind of review of payment applications and change orders, which is what the owner's rep's role here for number 5. But also, can you talk about what DSS's role with regards to supervision, right? Like where the association or an owner is engaging a contractor to do its work, but that doesn't mean that the association or the owner turns a blind eye and says, okay, we'll see you at the end of the project. Hopefully it goes well. So DSS, how would DSS be involved in that role of site supervision?
Well, in regards to that, let's start with this. Item number 5, perfect entry into that. We have associations representative. So identify the representative within the contract. It's extremely important. Okay, us as representatives, we're just that. We're an extension of you. We're an extension of ownership. We're out there. We're your eyes and ears. We're monitoring this project for you on your behalf, but with the expertise that we bring to the table, which is our background. Now, once that's identified within there, we have to ensure that the owner's representative, to call it DSS condo, is identified. And specifically, when it comes to final approvals on payment applications, change orders, and completion, be that substantial completion, along with your engineer of record being the one that's going to approve that. Now, during the construction administration, our involvement, our on-site presence is very high. We are on your site I'd call it up to 5 days a week or as needed, if not more, even Saturdays if you have to perform work. The idea is as your owner's rep, we're out there, your engineer's looking at specifications, specifics on the work being performed, call it, they chip this to the size that he has within his detail. It meets the Florida Building Code, ICRI standards, which are standards for concrete restoration. They're going to ensure that those repairs are the way they're being done the way they need to be done. Now we're going to look at it, and while we're there, we're going to ensure that they have the right amount of manpower, the right safety in place, protecting your building, protecting the residents of your building. And we're also going to be looking at this work as you, through your eyes, meaning what? Cosmetics. They're doing a stucco repair to the wall. We're going to ensure that once they're done with that stucco repair, it looks the way it needs to look, that your building doesn't look like it has major patches all over it. Again, we're there to be your eyes and ears, to protect you, to be the voice for the association. So we're there very often. We're on site essentially 5 days a week, depending on the project and what's going on. And we're within every angle. We're hosting construction meetings on site. We're building agendas. We're handing out the meeting minutes. We're controlling what's going on. We're basically the hub of information where everybody goes through us and directly to you, and the vice versa, you to us, and we go out to everybody else.
On that point, Michael, you touched on labor workforce, and I think that that's an important underrated item of supervision, because ultimately you are the eyes and ears for the association, and you're going to be on site to say, okay, well, how can they possibly meet this schedule that they're claiming that they will meet if there's 2 people working and this is a 15-person job, right? So being able to call that out on a daily basis and being able to notify the association's council, say, hey, listen, this provision requires them to have this many people and meet this schedule. I don't think they're going to meet it for this and X, Y, and Z reason. We have to send the appropriate notices to protect our claims under the contract. And I think I know that's happened to me. Danny, has that happened to you in some of your cases?
Yeah, absolutely.
Yeah.
No, it comes up quite often.
And it's actually right. You touched on something there, Alex, which is sending the appropriate notice. And I don't know if you want to go more into that. Noticing a contractor, typically it's spelled out in a contract, I would say an agreement of how that's to be. It's not so much pick up the phone and tell the contractor, hey, you're falling behind, and calling that officially being noticed. I think there's a little more to that. I don't know if you want to touch on that.
We were going to touch on that a little later, but Danny, if you want to go ahead and chime in on that now.
I was going to add to that eventually when you get into litigation, you have to prove that you gave these notices to support the claims or the termination or whatever else. And the best way to do that, and often what wins a lot of litigation in these types of cases, is whoever's got the best documents. So if your contract says you have to give 10-day notice, and I can point in litigation to a specific letter that was sent saying, here's the notice, you have 10 days to correct it, and then I can prove afterwards that they didn't correct it. I mean, that's as clean as you can get. And that's essentially what you want in every litigation case, is you want clean documents and you want lots of documentation supporting every one of the defaults or issues that you experience during the project.
That's a perfect point. So we can move on to the next slide. I know the notices are later down, but we can touch on that again later. So this next slide talks about some of the bigger. So when I'm negotiating a contract on behalf of an association, these are the first 2 provisions I look at to make sure that they're appropriately drafted, and I'll tell you why. In particular, insurance, the association doesn't need to take on any risk whatsoever for the operations that are occurring on site that are engaged by a contractor, right? The contractor has insurance. The contractor's subcontractors are required to have insurance, and they will list the association or the owner, developer, or anybody else who you're representing as an additional insured on those policies. And those provisions in the contract, the insurance one specifically, should spell that out, exactly what's being covered, exactly who's being named as additional insured. And more importantly, in the case of a master project or an association with multiple buildings, you want to make sure that every single entity that needs to be named as additional insured is actually named. And more importantly, that the contractor's insurance coverage is provided on a primary basis, non-contributory, so that the contractor's insurance is not looking to the association's coverage as a partner in this case. The insurance is going to be primarily responsible, and the contractor's carrier is going to be primarily responsible on that issue. And I'll touch quickly on indemnification before turning it over to my esteemed panelists. But indemnification in the state of Florida is important. I mean, really anywhere in any state, but in particular in the state of Florida, there's a statutory requirement and limitations on how indemnification gets handled. In particular, and I can get into specifics offline with anybody that has any questions, but the state does not allow the contractor to indemnify an owner for the owner's own negligence. And if they do, if the provisions state that and they allow for that risk, it would need to be capped or limited in compliance with the statute. So this indemnification provision, and to give a little bit of the definition or explanation of what that is, it's effectively protecting the association if a third party sues the association for anything that the contractor does on site or a subcontractor does on site. In that case, or if they've notified of a potential claim, the indemnification provision is where your attorneys would look to and say, okay, well, we received this notice from this third party. They've been injured or they've been affected by the operations on site. Let's look at who's responsible here. Oh, it's the contractor or the subcontractor. You can then turn around and say, hey, you are required to indemnify us for this third party claim because it is a requirement of your contract. Danny, I don't know if you want to touch on that a little bit.
Yeah, and I also wanted to add the example of where, for example, a association pays a contractor then doesn't pay his sub. There are indemnity provisions that will also step in and require that contractor to defend perhaps or indemnify the association in connection with any disputes that general contractor has with their subcontractor. So it's another way in which these indemnity provisions can step in to protect the association in those types of disputes.
Yeah, and just one other point on that issue, they have to be vetted by your attorneys. I think that it's vital for that purpose, but also the insurance coverage should be vetted by the association's broker or insurance agent as well to ensure that the property insurance provided by the association to its unit owners gels properly with the insurance provided by the contractors who are working on site, and make sure if there's any gap in any coverage, there's an understanding of where those gaps are, where those risks are, and an analysis of same. We can go to the next slide. Perfect. So, Danny, do you want to talk about correction of work?
Yeah, I'll go ahead. I mean, I'm a big fan of this picture. I like I put it in there because I mean mistakes do happen during construction projects, and there should be a provision in your contract that requires the association or that allows the association to reject non-conforming work, and the contractor should likewise be required to correct it at its own expense. And so you'll find often provisions in your contract that control that and protect the association. And similarly with the cleanup and protection of property and persons, there's a lot of disputes that happen at times during construction projects where construction can get messy and residents don't necessarily want to see the mess throughout their lobbies and other places. So it's just another one of those provisions that you can put in there that protects the association and likewise avoids disputes with neighboring property owners as well, because oftentimes if you're doing a lot of, I mean, just to give an example, chipping or something of concrete and it's creating a lot of debris, you can get into some disputes with neighbors. But I'll hand it over to Michael as well if you want to add anything on this, because it's definitely something you see more than I do.
I love the photo. It's great. I haven't seen that on site on any project yet, but I have to say that, yes, I completely agree. You have to make sure you're protected. You have to make sure that your legal counsel is involved. And I mean, the biggest thing here, again, on our side is this is one of the main reasons for having an owner's rep involved. I mean, during this process, it's yes, be protected in case it comes to that, but the hope is that it doesn't come to that. The hope is that you have an owner's rep involved who's on site, monitoring their activity, monitoring the work that's taking place day in, day out, the cleanliness of the project, the protection of the property and the persons on the property to ensure that things like this just don't happen.
That's exactly right. And just to touch on the cleanup and protection of property and persons, I'm not sure if anybody else had anything to comment on that particular provision. But I do want to touch on that because what's come up recently, due to unfortunate circumstances with regards to Champlain Towers, the effect of a job or a project on one property has effects on their neighboring properties, and neighbors are getting more involved. Neighboring condo associations, neighbors in general are getting more involved in understanding exactly, okay, well, what's the risk here of your work and how is your work affecting my property? So getting a good understanding of what the obligations are on the contractor to not only clean the site, but also protect the site as well as its adjacent properties is important, because ultimately what you don't want to have is to use Danny's example of chipping concrete. Okay, well, they're chipping concrete on one job site, but if that concrete or dust debris goes into a different job site and that is not related to the contractor's work and is neighboring association, they're going to have claims against the association for that, because ultimately they're required to not damage the neighboring property. So to make sure that those provisions are in the contract, and if there's any negotiations or communication that should happen with the neighboring property, to put them on notice of, hey, listen, we're doing a project. These are the steps that we're taking to protect your property, just so that you can avoid an issue down the line. That's really the one topic I did want to touch on, because it's coming and happening more often than I've seen in the past, in my experience. Okay, so I think we can go to the next slide.
Yep.
So in every single construction contract, there is a warranty provided by the party who's actually doing the work. And sometimes those warranties are a bit confusing, because you may have a 1-year warranty on the actual work, but then the contract requires them to do defect-free work. So that's where the interplay between warranties and contractual claims, that's where the attorneys get involved. And that's how we advise associations and counsel them throughout disputes on those issues. But Michael or Danny, can you talk to me a little bit about manufacturer warranties, installer warranties, and warranty coverage in general?
Yeah, I could talk a little bit about manufacturer warranties. Look, manufacturer warranties, we in the condominium world, we deal with so many. We deal with whether it be the railing manufacturers or the glazing, the glass itself, or waterproofing to paint, or the actual paint on the railing. The idea is at the beginning is reviewing those warranties and ensuring that you're properly covered, and covered for both, I'd always, labor and material. The majority of these warranties, manufacturer warranties, they're going to always attempt to provide you what's called just warranty on material itself, saying the material fails, we'll cover the material. But what about the labor? At the end of the day, there's a labor that goes along with this, and they want your product, they want your project. And it's going back to them and identifying that within their warranty and requesting that additional coverage, and ensuring that the contractor itself is an approved applicator of that product that they're going to be applying, to ensure that they are allowing this contractor to install that product and therefore them warranty it. And along with that, I call it the warranty coverage, a little bit of top, tab on here going forward, is understanding what they're asking for moving forward as far as maintenance, in order for you to have that warranty. And a perfect example, and I can give you a building, was they had railing installed, new glass railing, beautiful railing, was installed perfectly, inspected by the engineer, inspected by all parties, came out great. As time went on, you have to understand it's a big building, so they're moving from drop to drop. This railing installed and showing as completed has a completion date. As they went on and they got later on to the end of it, call it a year later throughout the process, when they went back and there was actually an issue with one of the glass, they came back and the first thing the manufacturer asked for is said, well, let me see your maintenance log of all the cleaning and what you were supposed to be doing with this paint. They were in shock to say, well, we just finished, and said, no, you just finished the building, your project, but you finished that a year ago. And if you look at your coverage, you have to have a maintenance log of every X amount of months of going and cleaning it using certain products and documenting that. So it's truly understanding those warranties and what it means, and if there's a maintenance plan attached to those warranties moving forward. I don't know if you want to touch on that a little bit.
Yeah, I was going to suggest, Danny, why don't you talk to me a little bit about how, in a construction defect context, how sometimes warranties and claims against the contractor are at issue, right? Because there's fingers being pointed regarding a claim. So go ahead and talk about that a little bit.
Right. And I mean, I'll start with, I wanted to make a point about the maintenance, because one of the biggest offenses that gets raised in every construction defect case is usually lack of maintenance. It's probably one of 4 major defenses that is raised in every single one of the cases. And so being able to prove, to Michael's point, being able to prove that you maintained it in accordance with whatever the warranty documents required or whatever the contract required is really key to any lawsuit that comes from that later on. And then as far as the warranty coverage is, kind of also to Michael's point as well, I mean, you're going to want someone to review the warranty to make sure that it provides the proper coverages. I mean, you could, there are claims that, essentially, to give another example, if a roof goes bad, you put on a brand new roof and now you need to replace it within the warranty period, you're going to want to look at the warranty to see, does it cover, like you said, workmanship? So was it installed correctly? And then likewise, is there a failure in the material? Someone's going to have to identify at some point down the line whether or not it failed because of a workmanship issue, or a material issue. And to the extent that it failed for something that wasn't covered under your warranty, the association could be left essentially specially assessing the residence or paying for that repair on its own. So you're also going to want to add or to add to that, you want to look at the time that's covered under the warranty. If putting a new roof, for example, to go back to that, are you putting a roof with a 10-year warranty or a 20-year warranty? Because the association may have to look at that for budgeting purposes and say, I'm going to have to put a new roof in another 10 years, or do I get one that's going to cover me for 20 years and not have to budget for it for a longer period of time. So those are all important considerations that the association looks at during the contracting phase.
Great. And then want to add to that, another, thing that we like to do at DSS does during the construction phase, call it, during the process, let's speak about waterproofing. You're installing waterproofing. Your waterproofing has a 20-year warranty on it. And you want to ensure you've already gone through the steps, you've gone through legal, you reviewed it, your owner's rep looked at it. Yes, your warranty is in place. It's now an exhibit to your contract. But during the process, it doesn't end there. One of the things that we do is while it's being installed, we're making sure that we have a representative of that manufacturer on site inspecting periodically to ensure that the workmanship is what it needs to be, to try to help you down the road in case you do have a defect. Going back to that, manufacturer is going to want to raise their hand and say, well, it's an installer error. It's not the material itself. Well, we want to go back and have that log and those email correspondence showing where you were on site and you confirmed that this material was being installed accordingly. You did your pool test, what you needed to do. So at the end of the day, we're providing you the tools you need. So later on, if it does come to that and you do have to go to legal and work with them, you're able to hand them all that documentation and say, here you go, guys, go forward from here.
Right. Yeah, on that point, Michael, I think that's unbelievably valuable. When you have, as Danny said earlier in the presentation, documentation is key, right? So if you have somebody there to say, oh, we were inspecting this property on this day, we noticed that the installation was done by this subcontractor, it was approved by this manufacturer's representative, then what is the manufacturer going to be able to defend himself when it comes to claiming that it's a user error as opposed to a material error? That's where it becomes the litigation. And then really we're trying to prove and make sure that the association is protected and using the provisions of the contract as a shield in this case on against those defenses that the manufacturer raises. But let's touch quickly on this point before moving on to the next slide, this change order protection. The involvement of not only an owner's rep like DSS or attorneys like Haber Law on this is really to protect the association from having change orders that could become costly down the line. As Michael alluded to earlier when he was talking about the scope of work and the bid review, there needs to be a good understanding of what exactly is included in a contract so that the association isn't hit with a change order later on and it raises the price of the contract, right? So the idea is to have a good understanding of the scope and a good understanding of what is involved in a schedule and what would happen in the event of, for example, a hurricane or weather or something else that would potentially extend that schedule and what the costs related to to that change. So if you're outlining that in a contract appropriately, there's no question as to how it gets handled down the line. And DSS and Haber Law are in the best position to predict what is a potential issue that could come up on a project because we've done this before, obviously. So that's really our goal here is to try to advise an association of, well, you may not be considering this particular concern, but because they didn't include this in the scope, it's important. Or because this provision in the contract doesn't attest to or doesn't address whether or how it's going to be handled, it's important that we discuss that now because we know that it's going to happen in the future. Michael mentioned something earlier as well that I'd like to bring up. Knowing if an association allows, for example, or is willing to allow work on a Saturday, that's important for the purposes of a schedule and whether or not a change order is necessary. If you're using Saturdays as a makeup day and that's how it's outlined in the contract, that's important so that when that change order comes in where a contractor says, hey, we couldn't do the roof yesterday because it was raining for an hour and we couldn't get the people on the job site, then you can say, well, great, you have Saturday and there's going to be no change in the contract. Go ahead and do the work on that day. And that's an important provision to be able to discuss and negotiate on the front end.
Absolutely. I mean, when it comes to change order protection, we get our clients, we just repeat it over and over again during the pre-construction phase, during that planning phase, involve the professionals, involve the Haber Laws of the world, involve the DSS of the world, bring everybody to the table, understand what you're getting ready to embark on, what you're going forward on. We, as Alex mentioned, we've all done this a couple of times. We have experience. We understand what can go wrong, and what to do to avoid those things, or at least protect you during the process. We always tell everybody, slow down to speed up when it comes to that part of the phase. Don't try to get to the construction so quick because you'll be hurt later on down the road. One example I'd want to give of a notice requirements when it comes to change order, especially when it comes to time change. And I'm sure, Alex, you've either included this or seen it in contracts, is the amount of time or notice that the contractor has to provide a change and extension of time, being weather delays. So certain weather delays, you don't want the contractor to come back to you 3 months down the road and give you a change order for 14 days of weather delays and says, well, this was all the way back then. If you remember, it rained that day. We want to make sure the contract has some sort of provision there that says he has X amount of days to provide that to us. I don't know if
No, he has that amount of time to provide it to you. He or she has that time to provide it to you, or they waive it, because ultimately,
Correct.
yeah, because the goal is to try to limit the amount of claims that are launched against the association. And if they don't, if a contractor is not complying with the notice requirements, there has to be some penalty as to where that comes from, right? So if we know that a windstorm or hurricane or rain passes by, and the contractor doesn't launch its claim against the association to add a day or two or however much time to the contract, then the association can stay confident that it's not going to affect the schedule. And the contractor is not complying with the language. So therefore, they have to live and die by the language of the contract. That's why the contract negotiation is so important, so vital. Time requirements for everything are important. And if you can move on to the next slide, we can talk about why.
Okay, right before we move to the next slide, we do have a question. I guess this relates to the warranties.
Sure.
Susie's asking, who's responsible to maintain documentation?
Well, that I can actually touch on that a little bit. The association is required to maintain its documentation with regards to the association issues, but DSS Condo sometimes will take on that responsibility, right, Michael? With regards to
right.
construction projects, by the way.
Yeah, okay, correct. Strictly the construction project that we're engaged on. If you have other things happening in the building, I can't help you there. We can, but it's part of the discussion. But no, absolutely. During the process, from pre-construction, from planning, all the way through the process of construction administration until the end, until the closeout, we house all your documentation and we store everything. We've learned that have everything in writing, have everything saved. We save to the fact that there's a schedule and it has to be revised to add 2 more days. We will never do a save as and overwrite that one. We will do a new date and have it because we want to see the change, understand the change. Even if it's 6 months later, we want to go back and figure it out. And at the end of a project, when we hand it over to you in a little USB, we're going to have all your documentation from your warranties to your closeouts to your permits to every agenda, meeting minutes, everything that was discussed, emails if needed. It's all put together in a nice little USB and handed to you. So later on, if anything happens, you go right back to that and you have all your documentation. So we take on that responsibility.
All right, now we ready?
Yep. And the reason that documentation is so important is because when there is a dispute, these dispute resolution provisions of the contract are going to govern which law applies. If the project is outside of the state of Florida, obviously the majority of people in this particular webinar are based out of Florida, but your companies may have projects and associations outside of the state of Florida, or in particular, the form to file the suit. So where the project is located, is that going to be determinant about what court you go to seek relief? And then lastly, with regards to attorney's fees, I always recommend that an association include prevailing party attorney's fees in the contract to protect against, if there is a claim down the line, if there is an issue that comes up where you have to engage firms like Haber Law to litigate on your behalf against the contractor, you're not also having to pay our attorney's fees. There is some mechanism for the association to recover the attorney's fees that are being incurred because of the contractor or because of the claim that's at issue. So that's what this dispute resolution major term and condition portion of the presentation is all about.
Yeah, I wanted to add a point to that Florida follows the American rule, which is everybody pays their own attorney's fees unless you have a contractor statute that says that, you have to pay the prevailing party's fees. So it's really important to have an attorney's fee provision, to Alex's point. Otherwise, litigation gets even more and more expensive. And then likewise, on the governing law side of it, I've seen cases where people won't have a contractor or an attorney review their contract, and then it'll say that, to the extent that there's any dispute, it's governed by the laws of Massachusetts. And in litigation, that makes these cases extremely complicated because I practice primarily in Florida. Most construction lawyers in Florida practice primarily in Florida. If I have to go learn construction law according to Massachusetts law, it makes it a lot more complicated. And the last case that I litigated like that was extremely expensive. So it's important that these things also get hammered out during the negotiation.
And I want to give a very brief example of why attorney's fees are important in particular, because, for example, if a subcontractor has a lien on your property or a potential lien claim on your property, there's a statutory mechanism for them to recover attorney's fees. It's 71329. They will then have the right to enforce that statute and seek attorney's fees against not only the contractor who failed to pay them, but also the association whose the lien is on the property. It's a pretty broad statute. So including an attorney's fee provision in the contract between the association and the contractor is vital, so that if and when there is a dispute by some subcontractor or supplier down the line and they launch it against the association can be comfortable and say, well, listen, I'm going to be engaging my attorneys, but I don't have to pay your attorney's fees. The responsibility of whoever prevails in the lawsuit is going to be in charge of collecting on those, right? So if a subcontractor sues an association and a contractor and the association engages counsel and it's the contractor's responsibility and they fail to pay their subcontractor, guess who's holding the bag in terms of attorney's fees? It'll be that contractor who failed to pay them in the first place, not the association having to pay their attorneys and then also pay potentially a lien or attorney's fees of the subcontractor involved. And I know we touched on notices before, so I'm not going to belabor this point. Who, where, how to send it, how the documentation is done, whether it's by FedEx or email, whether it's to a particular person or to a group of people. All of those details would be outlined in a construction contract and are vital in order so that you can maintain your claims and make sure that the appropriate parties are noticed. If we can go to the next slide. And these are the last two of the major terms and provisions. I'll touch on these briefly and then let Danny and Michael talk on these issues. The termination provision in the contract are important because, you know, sometimes a project will go sideways and the association needs to have an understanding as to what their options are in order to move on from that contractor. And the difference between cause and convenience is when the contractor, if and when the contractor fails to comply with its obligations under the contract or they default under the contract, that would be a termination for cause. If the association doesn't want to even engage or investigate whether or not they've defaulted and they just have lost confidence in this contractor for no reason other than they just don't like the way the contractor is doing its work, they can do a termination for convenience. And there's business implications usually between the two of them. Usually a termination for cause doesn't include any fee or payment for work not performed, and usually a termination for convenience will include some kind of kicker for the contractor because they're not in control over why they got terminated. But we can touch on exactly, you know, offline. We can talk to anybody who has any questions about whether or not a termination for cause or convenience is appropriate in certain circumstances. And I can tell you, and I can speak for Danny a little bit. We almost always try to frame a claim or termination for cause because that sets up litigation in a better way than if the association just decided to terminate it for its own convenience.
Right, and I'll add to that too, that it's a different measure of damages typically, I think, which you kind of touched on already, but typically when you're terminating for cause, the contractor's defaulted, they're essentially in breach, and so from the point of termination forward, if it's a proper termination, you don't have to pay the contractor or anything else. Whereas if it's a termination for convenience, typically it's spelled out within the contract what their measure of damage is, but you'll see something that says that you have to pay, for example, a portion of the profit on the unpaid work. And so you could still terminate for cause and have to pay that contractor a certain amount, even for work that they didn't perform because they had an expectation that essentially was breached in the contract. So it's another important provision, and it'll outline how you can do it, what notice requirements have to be given, and they tend to be different for each one.
We actually have a question for you guys, if you don't mind. You know, we get asked this often. Call it for termination for cause. The contractors failed to perform. They've been properly noticed as per their agreement. Been sent to them. They've gone back and forth. Association decided we're going to terminate. They've gone to legal counsel. They've advised the contractor we're terminating you for cause. how soon can they start looking for, call it a secondary contractor to come in here? You know, they're mid-project, they need to continue moving forward. How soon can they literally bring somebody in and start performing that work? And how would they need to document that at any additional costs if they're going to be able to put that on the parent contractor? I don't know if you're able to elaborate a little bit on that.
Sure, I can touch on that briefly. I'm going to use a very common attorney response, and I know you're not going to like to hear this, but it depends on the contract, right? If the contract requires that the association provide an opportunity to the contractor to cure, right? If the contract requires them to be given an opportunity, then you need to give that opportunity, because then if you don't, then you could be in default of the contract because you're not allowing the contract to do its contractual rights. Now, if the opportunity to cure has been come and gone, if you've given them that opportunity and they're still failing, the association can engage a contractor immediately and say, listen, you're coming in as a completion contractor, and in the state of Florida, the case law says that if there's a termination for cause, if there's a default in the contract, the association or an owner in any circumstance would have the right to engage a completion contractor and seek the damages against the contractor that's been terminated. So that's a pretty common damage model. But at the end of the day, and I'm going to belabor this point because that's exactly what I'm trying to do here, which is the contract language is vital. It's the end all be all. It's what defines it, and to the extent that you can include what exactly those completion cost damages would be in the contract, that's even better, right? And so, Danny, I know you're nodding your head, and I think you wanted to say something about.
I'm in agreement with everything. I have nothing to add. I mean, typically, I mean, in terms of engaging a replacement contractor, I mean, you can negotiate with them before. There's certainly nothing that prevents you from starting to have the conversation. If you know that it's coming up, there are times where you know that a contractor is not going to be able to complete. They've basically told you that they're going to default or they're going to come up, leave the project. I mean, you can start having negotiations and conversations with replacement contractors as soon as possible. And an association certainly shouldn't wait until you terminate the other contractor to then start looking for someone else to replace the defaulted contractor, because it could be weeks, it could be months. You may not find someone at all. And so as far as having conversations, you can certainly start before, but in terms of engaging them and contracting them, you want to wait until the other contractor's off the project. You don't want to have two people contracted at the same time without knowing what's going to happen with the original contractor.
Just to touch on bond, because we haven't mentioned that at all yet, I want to kind of move on to that topic. Let me just give a brief background as to what a bond is and how it's important. A bond is essentially a tri-party agreement between the association or an owner, the contractor, and the contractor's surety or a bond company. So essentially an insurance company that is ensuring that the contractor is doing its job appropriately. There's two different kinds of bonds, a payment bond and a performance bond. The payment bond essentially guarantees that the contractor will pay its vendors downstream. And if there is a lien imposed or a notice of lien imposed by one of the subcontractors or suppliers, the association can turn to that payment bond and say, your responsibility, you're the responsible party for this lien, and it'll never attach to the property, creating a cause of action or a cloud on the title of its unit owners. A performance bond is what Danny touched on briefly, is if they're not performing appropriately, or they're delaying, or they're breaching the contract for any number of different reasons, the association or the owner can look to the surety, and as long as they comply with the terms of the bond, they can have the surety step in and essentially dictate how the contractor is going to do its work on the project, because ultimately the surety, aka the insurance company, wants to make sure that it's insured, the contractor doesn't breach and expose the insurance company to more liability. So in this circumstance, a bond is sometimes recommended or required, depending on the circumstances. If there's a loan involved, there's a lot of different reasons why that would be involved, but it's a small price to pay for a lot of safety and protection and peace of mind from an association's perspective, because you're no longer having to deal with a contractor directly. Sometimes the contractors are recalcitrant, or they're difficult, or they don't want to communicate with you, but they provided a significant obligation to their insurance company to provide that bonding capacity. So they don't want to breach their obligations under the surety, because a lot of times they'll have a personal guarantee, for example, that goes directly to them, and you'll have a lot more leverage if there's a bond in place.
And I'll add to that then, because something with the termination kind of plays into the bond as well. Typically, when you're talking about a performance bond and you're talking about an association who comes in or wants to complete a project and you're dealing with a defaulted contractor, there's certain termination provisions that you have to look at within the contract that then comes into play in the bond as well, in terms of how you have to terminate and what notice you have to give to the bonding company as well, because they'll have several remedies under the bond that they can that they can choose from. They can either pay money, they can find someone to replace it, or they can deal with that contractor directly. And so there are different options that you'd want a lawyer to look at the termination provision of your contract and the bond itself as well, to see what remedies are going to be available to finish this project out, or if the bonding company is just going to pay to have it completed.
Right.
And I think we actually have a question. You're going to say that?
Yes.
We
All right,
actually have a
yes.
question.
Yeah, we have a question from Crystal. Says, isn't it true that you don't get to choose a new contractor if the performance bond is executed?
So I can answer that. The bond has options for you to if you launch a claim against the bond company and or the contractor, the bond company has options to be able to engage whoever they think is best for the project, because ultimately they're the insurance company, guaranteeing the work by the contractor. They very well may pick the same contractor that you're terminating or seeking to terminate, because for a number of different reasons. One, that contractor's on site, already has a workforce that knows exactly what they're doing, and they understand the scope of the work. Now, for a lot of different reasons, the bond company may choose to engage a different contractor that's not the one that you're terminating, but ultimately the decision of who they engage is up to the bond company. That is accurate. Crystal, you're right. You do not pick the contractor that the bond company picks to finish the work. However, if the bond company picks a contractor, whether it be the contractor you're terminating or another contractor, and that contractor is failing for whatever reason, you could then terminate the bond company and engage your own contractor and launch the claim against both the original contractor and the surety for breach of the bond. So we only have a few more minutes, so I'm going to run through this pretty quickly. These are the critical exhibits that we were talking about beforehand: the schedule of values, understanding what the value is on the contract, what each line item is defined, and the scope of work is outlined therein. Schedule, we've talked about that quite a bit already. Drawings and specifications, that outlines the actual scope of the work from an engineering perspective or an architectural perspective, so that everybody is aware of exactly the detail involved in the actual work being done. Allowances, Michael talked about that earlier. Allowances are those items that cannot be defined or lump sum. So you would have an extended amount of basically a contingency or amount in there that you think is what the estimated cost is, but it can go above that. Certificates of insurance are they speak for themselves. It's the insurance involved in a particular project. Warranties, we already touched on that. Suli, if you can go. So a release of lien template. That's where the attorneys essentially provide a form to the contractor, or the contractor sometimes will have its own form where they want to, with each payment application, they will submit this template to release their lien on a progress basis, so that you're assured as an association that there is no cloud on the title of the property or the common areas. Assumptions, clarifications, and exclusions. I know Michael and I were talking before our presentation that how important this particular exhibit is, because a lot of times that particular exhibit will take priority over the language in the contract. So that exhibit needs to be reviewed by both your owner's representative and counsel to ensure that if there's any conflict, they are resolved and are agreed upon beforehand. And then the next three: hurricane preparedness plan, phasing plan, and staging plan, are all kind of part and parcel of the same thing. You need to be aware of, in the event of a hurricane, or in the event of a phased project, or in the event of logistical issues, whether there's a crane involved or not, that the contract and the exhibits outline exactly how the work is going to be performed and what happens in the event of those circumstances. So, Michael, I don't know, we've now run out of time, but if you want to touch quickly on some of these exhibits, we can before we move on to the end of our presentation.
No, I mean, you did great. I mean, the only one: assumptions, clarification, exclusions, as we spoke. I mean, contractors will submit this to you as a bid qualification, qualifying their bid, they call it. So it may not, don't look for exactly some of the assumptions, clarification, it's just qualification of bid. It'll be a little sheet, and they're just going to be certain line items. For example, I know the specification says we need to remove this and this and to perform this work, but we're saying that's not included within our price. Certain items like that, you just want to make sure you read through that, you understand that it's not just an extra page, it's part of their bid.
Okay, I know we had some examples that we wanted to talk about, but I think we've run out of time. Do we want to? Yeah, do we want to use, let's just go through one example and just explain it, and then we can talk about, we can leave it to the end of the presentation. So in this example, it says, this is language that says, in addition, the association shall hold $150,000 for contingency. Michael, why is that an example of what to avoid?
So if you're going to have contingencies, you put it in place. Us, DSS, we put together contingencies for both soft costs and hard costs. You know, you run it by your attorney. You as an association, as owner, have an understanding of that. There's no reason to share that information with the contractor. That does not need to be in the contract nor the bid. Contract does not need to know what you have as a cushion to assist you in case things go over with change orders, because they will, in a sense, try to attempt to take advantage of that and get that from you.
Great. So to wrap it up, Suli, if you can go to slide 25. Yeah, these are just examples of things that we can do to tear down a bid sheet or challenge it. But one more slide. So ultimately, what is the best way to avoid litigation? And that is to engage your attorney with every contract, to get an owner's representative like DSS Condo to review not only the scope and the actual work that's being performed, but also all the documentation involved. And ultimately, it's to negotiate an ironclad contract to make sure that every single provision, the association has a good understanding of where the pitfalls are, where the risks are, and how to best use the contract as a sword and as a shield when it comes up on the project. If there's any other questions at all, please do not hesitate to reach out to us. If you go to the next slide, there's our email contact is on this page right here. Please feel free to give either Michael or Danny and myself a call or an email, and we would be able to help you out as best we can. Thank you for
Happy
attending.
to assist.
Yeah, appreciate it. Thank you for attending, everyone, and we're looking forward to hearing from you soon.
Thank you,
Thank
everyone.
you, everyone.
All right. Thank you, everyone.